and make it clear that the Chinese Communist Party is waging what they call legal warfare using the U.S. courts.
The answer to a threat cannot be Republicans' tort reform wish list, and our constituents deserve better than a system where only the well-connected and the rich survive. Becoming more like China won't stop China. It won't work in our court system, and it won't work in our trade practices.
This hearing is important, but it ignores the structural shift in our government in favor of the autocracies and kleptocracies who are Donald Trump's political soul brothers.
We have a distinguished panel, and I recognize that you're able to go into areas beyond any one piece of legislation. I'll now recognize myself for that opening statement. Again, I want to thank the witnesses and make it clear that the Chinese Communist Party is waging what they call legal warfare using the U.S. courts. Although this is not new, the previous administration elevated it by covering repeatedly a number of the areas in which the CCP has been, in fact, using our system against us. This is over and above the 10,000 attacks a day that occur on the internet. This is over and above their spying. This is over and above the abuses that occur on companies in China. This is, in fact, using our patent system, our trademark system, and our courts to their advantage. We take this seriously, that we will not be abused any longer. Legislation and rule changes by the administration need to happen and happen now. Let's make it clear. There are legal actions that the Chinese businessmen and others do, and we want to make sure they're protected, just as we want to make sure that American companies, European companies, and individuals all over the world have access to our courts, to our patent and trademark system, and to our economy. In fact, some of our own laws have made it easier for the Chinese to take advantage of us. Our courts are the backbone of our Constitution, and we will protect it. Legislation that sanctions the PRC alone cannot be enough. We also have to strengthen the system itself from this type of activity. One of them is, in fact, open and transparent disclosure of who is truly behind a litigant. That includes third-party funding of litigation. It also includes, and should include, a thorough recognition that often there are a series of shell companies, even U.S. Subsidiaries that, in fact, have little to do with anything except covering their true source. All of that is not new. We see it in criminal operations, in human trafficking, in drug smuggling, in commercial fraud, and that is not limited to any one country. But the fact that it's backed by a powerful country who is using and weaponizing this is particularly disturbing. As we all are aware, often we are just a few weeks, few months, or maybe a few hours in new technology ahead of China compromising it and using it. That includes a look-alike of the F-13. That includes a duplicate of the CERN Super Collider new version. That one will be out before ours is built here in the United States. So we're not going to be able to fix it all here today, and it's not all within our jurisdiction. What is within our jurisdiction is to look at and to make available greater transparency, to empower our judges to order that transparency, and in fact to make it clear that a case should not go forward if, as is constitutional, a person accused of anything criminally is entitled to be faced by their accusers, their true accusers, which would include those who have people step forward. That is our law. But in civil matters, that often is a one-way street. Defendants under Rule 26 have to disclose if they are insured, have to disclose, quite frankly, their own financial condition, and even the financial condition of their principals. That is not always the case in the case of the plaintiff, and we need to have that. In preparation for this hearing, I have met with a great many companies and law firms who use third-party litigation funding or who partner with other companies. None of them object to, in fact, the transparency of disclosing that. Many of them have cautioned that the discretion by the judge as to admissibility to the jury is a different story. And I want to make that clear because it is not the intention of this chair or of any legislation I have yet seen to interfere with a judge's decision on admissibility. But when it comes to the right to know, whether in camera or otherwise, this information is critical in making the decision about protective orders and the conduct of the case. The subcommittee has broad jurisdiction as to the courts, but we want to use it wisely. And in this case, recognizing that transparency is one of the most important tools that we have, we want to make sure that it is brought to the attention of everyone. As I said earlier, this hearing does include a number of other pieces of legislation that I believe our panel is able to answer, and we appreciate your indulgence when those questions are asked. And with that, I recognize the ranking member for his opening statement.
Thank you, Mr. Chairman, and thank you to the witnesses for being here today. This subcommittee has held a series of bipartisan hearings over the last few years on the threat from the government of China. As a strategic competitor, China is seeking to develop cutting-edge technology to win the so-called AI arms race with the United States. It also competes for soft power around the world, competes for economic predominance, and competes for strategic resources. There is nothing wrong with competition. There is a problem with breaking the rules to get ahead, and that is what China has sought to do. Over our hearings, we have examined cases of economic espionage, threats to American intellectual property, cybersecurity risks, and the different ways these actions by China threaten U.S. national security. Today, we're here to examine the use of our court system by Chinese actors. We absolutely agree that China is seeking to gain ground in our strategic competition by encouraging Chinese businesses to harm American companies, and that can include through our court system. I've enjoyed working with Chairman ISSA and my colleagues on these bipartisan hearings, and I sincerely hope we can continue to examine the threat from the government of China to our national security, our economy, and our power abroad on a consensus basis. But there are areas where we have disagreed. Last Congress, this committee slated a partisan bill for markup that would have prevented companies on certain sanctions lists from obtaining new U.S. patents or enforcing the ones they already own, devaluing U.S. patents, and violating international agreements. While the Preventing Adversarial Patents Act was removed before it could be considered by the committee, the bill was a reminder that there are significant disagreements between the two parties on this issue. So I worry that this hearing on China's, quote, abuse of the U.S. courts may be a Trojan horse to disguise a very different agenda. I fear that as a so-called solution to the China threat, I will hear proposals like you can only file a case if you disclose all of the funders of your cause, or you can only file a suit if you are rich enough to pay a huge bond in case you lose. Or let's start limiting discovery rules and make them more restrictive. Or we'll flip the presumption of enforcing foreign judgments wholesale and adopt China's restrictive approach. The answer to a threat cannot be Republicans' tort reform wish list, and our constituents deserve better than a system where only the well-connected and the rich survive, because that's exactly what we would get from that list. This world I just outlined would mean that the big guys, the oligarchs, get their day in court, but the little guys, the Davids to those Goliaths, would be shut out. America's justice system has for so long been a shining light of equality in the world. And we must safeguard this impartial justice system now more than ever. Becoming more like China won't stop China. It won't work in our court system and it won't work in our trade practices. But it's a reasonable concern. Our democracy has been under fire by wannabe authoritarian Donald Trump and his White House cronies, the very big guys who could benefit from all the proposals I just mentioned, who do not care about justice and the rule of law. These folks are the ones who let Democratic senators get tackled to the ground at news conferences and who block members of Congress from federal facilities. These are the leaders who tell the DOJ to investigate members of Congress who dare criticize the president and who nominate far-right MAGA loyalists like Emil Bovee to federal judgeships, knowing that these sycophants will put Trump's whims above the Constitution. And if we start chipping away at our impartial justice system and make it harder to access, Americans will lose their ability to challenge these assaults on our rights against these rich, connected oligarchs. We cannot let our system become the playground for the big guys, the oligarchs like Donald Trump and his cronies. That's not justice, and we must protect a system where no matter their status, anyone can walk into a U.S. courtroom and be treated as an equal. So again, I thank the chairman and our witnesses, and I look forward to exploring this important issue, and with that, I yield back.
Look, in America, everyone is allowed to petition the court for relief, regardless of the depth of their pockets or their country of origin, making it harder for litigants to access the courthouse doors, even in the name of strategic competition with a foreign power, would make us less like America. That's not acceptable, obviously, yet that's exactly what some have suggested, instead of actually developing government policies that make us strong versus China and prevent illegal subversion and interference from China and Russia. In the context of our competition with China, we should never forget that those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. That's Ben Franklin. This has been a matter on which there's been strong bipartisan agreement in the past. I hope Republicans and Democrats on this committee can continue to uphold this basic yet vital framework, as difficult as Donald Trump has made it. I yield back the balance of my time.